Hi there. Today I want to talk to you about something that I have described as the new censorship. So when most of us think about the phrase a government censor, we're probably imagining something like an anonymous government official sitting in a dark room watching movies, deciding what's safe for public consumption and what's too dangerous. A job, by the way, that we used to have in Canada. That used to be something someone did. Or we might think of Soviet-era party men arresting citizens for expressing ideologically impure ideas or for criticizing the political leadership. But there's actually a new kind of censorship that is emerging. And this is a censorship that is more subtle, but perhaps more pernicious. And these new censors claim independence from the government, but they're actually empowered by the government through legislation and regulation. And they are just as passionate about stamping down on dissenting viewpoints as the classic commissar. These new censors are regulatory bodies, like professional regulators, to whom the government has delegated authority. Professional regulators oversee fields like law, healthcare, accounting, teaching, psychology, and they are empowered by the government through legislation. Canadians in regulated professions need the government's permission to do their jobs, and that permission is granted by these self-regulating professional bodies that have their own systems of rules and discipline. But every Canadian, including those in regulated professions, have a constitutionally guaranteed right to freedom of expression. And a concerning trend is emerging where individuals who are members of these regulated professions are facing discipline for private, off-duty speech that is unrelated to their profession. Their speech is attracting discipline from these professional regulators for the same reasons that speech attracts censorship in the most classic cases, because it's heterodox, ideologically non-conforming, politically unpopular, or controversial. I've just written a new paper about this topic for a think tank called the Macdonald-Laurier Institute. I'll link to the paper below. It's called The New Censorship, Regulatory Creep, Professional Regulation, and the Growing Limits on Free Expression. I can't wait to tell you all about it. If you're new here, welcome. My name is Christine, and I'm the litigation director at the Canadian Constitution Foundation, a legal charity that fights for fundamental freedoms in Canada. I upload regular videos about our ongoing legal cases and about other interesting developments in constitutional law in Canada, like the topic of professional regulation and freedom of expression. So if that sounds like something you'd be interested in, please hit like and subscribe below. It really helps my videos out a lot by making them more visible on YouTube. The algorithm really pushes videos that have engagement, like likes and comments. Also, please remember that nothing in my video is legal advice. If you have your own legal question or problem, please consult your own lawyer. Okay, so I want to tell you about this new censorship, which is taking place through professional regulators. And as I mentioned, I've written about it in this paper, and I'm actually pretty happy with the timing of the paper because I didn't know that this was going to happen, but it came out right when Jordan Peterson is back in the news. And his case is probably the most famous or most well-known case about censorship by professional regulators. And we were involved in his case as an intervener. I've done a few videos about what happened in his case, which you can find on the channel. But basically, Peterson, who is a clinical psychologist, he was ordered to do re-education by his regulator because of some comments he made on Joe Rogan and on Twitter about various political, social, and cultural topics. And some people who were not patients of Peterson's and who don't like Jordan Peterson, they objected to his comments, so they complained to his regulator. And there's been some confusion about what actually he said that led to the order for re-education. So I'll tell you what was investigated and what was of concern to the college. So first, there was a comment he made on Rogan where he was talking about a former client who had come after him with what he called a pack of lies and who he called vindictive. This was a different, unrelated complaint, and he was saying this is something that he was subject to, and that complaint ultimately was dismissed, but he was kind of complaining about it. Later in the podcast, during a discussion where they were talking about climate change and air pollution, he stated ironically, as a criticism of, environmental activists who don't always think about the unforeseen consequences of their policies, he said, well, it's just poor children and the world has too many people on it anyway. And he clarified in the following sentence that was, of course, a joke, and his point was to sort of criticize environmental activists for not having concern for children in developing countries. Another tweet that was of concern was where he called a Ottawa city councillor named Catherine McKenney, who uses they, them pronouns. He called McKenney an appalling, self-righteous, moralizing thing. And this was in the context of the Freedom Convoy. Peterson also tweeted about Elliot Page, a transgender actor who used to go by the name Ellen Page. And he said, in the context of some, I think it was a Pride Month post about Page, he wrote, "Remember when Pride was a sin and Ellen Page just had her breasts removed by a criminal physician?" He later followed up that tweet with a post on his website kind of explaining his position on various transgender type issues. He also tweeted calling Jerry Butts, who was the chief aide to the Prime Minister Trudeau, he called Jerry Butts a prick. And he also tweeted in response to a plus size model who was on the cover of Sports Illustrated. He called her not beautiful. So, contrary to what a lot of people are saying on Twitter, a lot of people are claiming that Peterson was actually disciplined for telling someone to kill themselves. That did not happen. That is not correct. Now, there was a complaint about a tweet where Peterson was engaging with a person who was tweeting about overpopulation, and Peterson replied, "You're free to leave at any point." The college dismissed that, finding that it was maybe provocative and inflammatory, but could be interpreted as a joke or innuendo, and it didn't rise to the level of disgraceful or dishonorable or unprofessional conduct. So there was no discipline in relation to that tweet. So when people say that, that's not correct. But actually, I think you could say the same thing about all of the other comments. They're provocative, inflammatory, but most of them are innuendo or, a joke. They're also off-duty comments. He's not, engaging in the practice of psychology when he's commenting on whether or not he thinks someone is beautiful or not. I personally wouldn't say that. I don't think it's a very nice thing to say, but that's not the role of the regulator to police niceness. There's no connection between those comments and the practice of psychology. And just because you're a psychologist from the moment you wake up in the morning to the moment you go to bed doesn't mean that the regulator has the ability to discipline every single thing that you say and do. If the off-duty speech, meaning the speech he makes in his private life, is not in the context of, treating a patient or part of his clinical practice, then the regulator really has a higher obligation to show that the speech could harm the public interest. And that doesn't mean the public interest writ large, like it's a good idea to be polite and that's the public interest. No, that's not what that means. It means the public interest as it specifically relates to the practice of psychology. And the further the speech is away from that, the bigger an obligation there is on the regulator to explain itself. So in Peterson's case, I think that those off-duty comments are about social, political, and cultural issues. The regulator said that they could constitute professional misconduct, though, and they ordered him to take this re-education program. And the regulator actually says that that isn't discipline, but really it is discipline in its effect. It's a public shaming. It's also a cost burden because Peterson needs to pay for his own re-education for an indeterminate amount of time. And I think that what happened here is that the college really did not do justice to Peterson's charter rights. They barely even considered his charter right to freedom of expression. They interpreted their statutory objectives in a way that was overly broad. They made this claim that the tweets come under their jurisdiction, but really it's outside of their mandate to regulate in the public interest, to police tone and politeness. And the statutory goals of the regulator were not properly balanced in his case, I think, against his right to freedom of expression. They also didn't interpret his comments in the full context. Like, a lot of these were sarcastic jokes, or they were made in the context of a back and forth exchange. And they're made on Twitter, which is not an environment that allows for kind of like a nuanced development of ideas. So Peterson challenged the order for re-education. He took it to divisional court, but he lost. We intervened in divisional court, but ultimately Peterson was not successful there. He tried to appeal to the Court of Appeal, and then tried to appeal to the Supreme Court, but he was denied leave very recently by the Supreme Court, which is why he's back in the news. So now Peterson says he's going to try out this re-education out of what he calls morbid curiosity. And I have to admit, I am also curious about how this is going to go. I can't imagine being a person trying to tell Jordan Peterson how to talk. I don't expect it will be a pleasant experience, but I'm sure Peterson's going to tell us all how it goes. So curious to see how that goes. But I think more broadly, his case is an important one because it has brought to the forefront of public discourse the expanding claims of professional regulators over more and more of the lives of those people who need government's permission to do their jobs. Like Peterson, people in regulated professions may be subject to discipline for public statements they make on sensitive topics like politics, religion, culture, society. And there's a concern among many people in regulated professions like doctors, lawyers, accountants, nurses. There's this concern that these statements will now result in discipline, even if it's completely unrelated to their profession. And I think that this is censorship for the most classic reason. It's unpopular speech. And it is being carried out by individuals here, though, that claim independence from government, but who are in fact empowered by the government through legislation and regulation. But professional regulators don't just have an unlimited and freewheeling power to regulate every single thing one of their members says. As I said, while someone might be a psychologist or an accountant or a lawyer from the moment they wake up to the moment they go to bed, that doesn't mean every single thing they do is as a matter of professional discipline. A professional regulator aiming to restrict its members' speech needs to demonstrate that the speech it's assessing is directly related to its primary mandate of regulating professional practice in the public interest. And that means public interest as it relates to the profession, not just any single thing that you think is in general public interest. It needs to relate to that specific profession. And I think the growing problem is that regulators are becoming overly generous with the scope of their statutory objectives. And that leads to an overregulation of off-duty speech. And review by the courts is not a guarantee that this overly expansive approach to regulating speech is going to be corrected, because the courts, when they get these cases, they're called judicial reviews, and they're often done on a very deferential standard, a standard called reasonableness. And reasonableness means it needs to follow a logical chain of reasoning and be reasonable in light of the facts and the law. But it doesn't mean it needs to be correct, which is a higher legal standard. Under a correctness standard, there can only be one correct outcome. And when the reasonableness standard is applied, it means more deference is being given to the response or the decisions by these professional regulators. And Peterson's case was decided under that more deferential reasonableness standard. For some people, Peterson's case is maybe challenging to sympathize with. Like, people have strong views on Jordan Peterson, and sometimes it kind of clouds people's vision. They'll say, I just don't like Jordan Peterson, so who cares? But consider a few other cases where this has happened, involving people who aren't as famous and who aren't as polarizing. So in the paper that I've written for MacDonald Laurier Institute, I consider some of these cases. I consider the case of a nurse named Carolyn from Saskatchewan, and she was subject to discipline from the nursing regulator for what I think most of us would see as really gentle criticism of Canada's government healthcare system and criticism of the end-of-life care that her grandfather received at a nursing home. And honestly, you'll be shocked that these Facebook posts that she was investigated for resulted in discipline because of how really innocuous they are. And this shows the problem with the regulator policing off-duty speech. So she was disciplined for reposting a newspaper article that said there needs to be better palliative care training in Canada. It's an article in the Vancouver province. And she was criticized for saying the following about the end-of-life care her grandfather received. I'll read it for you. She wrote, "It's evident that not everyone is up to speed on how to approach end-of-life care or how to maintain an aging senior's dignity. Don't get me wrong, some people have provided excellent care, so thank you very much for your efforts. But to those who made Grandpa's last years less than desirable, please do better next time. And a caution to anyone who has a loved one at the facility mentioned above," she names the nursing home, "keep an eye on things and report anything you do not like. That's the only way we get some change." And look, she was disciplined for that. And I think this is actually the exact type of speech we need, and we need it from nurses. We want nurses to advocate for improvements in our healthcare system. They're the ones who see it most up close. The college found that these posts contravened the code of ethics for nurses and were professional misconduct. She was reprimanded. She was ordered to pay a $1,000 fine, to write 2 self-reflective essays where I guess she, self-flagellates says how bad she was to complain about the care that her grandpa received and ask for improvements. And she was also ordered to pay $25,000 in legal costs. We were involved in her case, and Strom had to go through all of these legal hurdles to have this discipline finally overturned by the Court of Appeal, which correctly said that disciplining this kind of expression would have a chilling effect on the speech that the Charter seeks to protect, and it would preclude registered nurses from using their unique knowledge and professional credibility to publicly advance important issues. And the court found that the regulator had given insufficient weight to her right to freedom of expression. And by the way, her case was considered on the standard of review of correctness because it was a statutory appeal, unlike Peterson's case, which was considered on a standard of reasonableness. So this sort of highlights how the standard of review really matters. I'll tell you about another case. I researched all these cases and I just am shocked to see what I found. So these other 2 cases involved Ontario physicians who were disciplined for texts and emails that they sent to the head of the Ontario Medical Association, which is kind of like the bargaining unit for doctors. They bargain with the government. And the OMA had reached a pretty unpopular agreement on fee schedules, physician fees with the government. And a lot of people were unhappy with it. A lot of doctors were unhappy with it. And 2 doctors sent the president of the OMA some unhappy emails. Some of them, one of the doctors included a bunch of profanities, a lot of 4-letter words. Another one said, "You are a turd," and said, "How much are the Liberals bribing you for this deal?" And shockingly, these were emails just sent to the OMA and to the president of the OMA. And these private messages about the financial and economic interests of doctors to their bargaining head, it resulted in an investigation of the doctors and discipline. The disciplinary committees in the case of both doctors pointed to college policies on courtesy, civility, and public trust. But, private emails to the head of the OMA about fees, that doesn't undermine public trust. Like, nobody thinks a cardiologist is less able to operate because he objects, even forcefully, to the bargaining tactics of the OMA. This should be considered completely outside the scope of the regulator and should be given no deference. But the doctors in this case did not challenge the decision, including a doctor who was given a 1-month suspension for his license for advocating for his financial interests. That to me is crazy. Another case I want to tell you about involves a complaint about a physician named Dr. Polydoulis for comments that she had made during the COVID-19 pandemic about changes to the centuries-old ritual of Holy Communion at her Greek Orthodox church. And the Greek Orthodox Church, when they practice Holy Communion, they use a single communion spoon, like a communal spoon. And in 2020, the church adopted a policy of using multiple spoons. And there are theological implications and beliefs like religious beliefs about the communal spoon that are held among Greek Orthodox congregants. And, Polydoulos criticized the change on theological religious grounds. And she criticized the change in a verbal exchange she had with her priest and in an open letter she wrote to the Archbishop of the Greek Orthodox Church in Canada. And as a result of those, her expressing her religious views, a fellow congregant complained to the College of Physicians, alleging that Dr. Polydoulos had failed in her duty as a doctor by not warning people about the risks of disease in a communal spoon. And Dr. Polydoulos argued that she's entitled to express her religious beliefs and that she was not engaged in the practice of medicine when she expressed her personal religious opinions. But the college nevertheless investigated and they ordered a caution. On appeal to the Health Professions Appeal Review Board, that order for caution was upheld, and the board stated, without much further explanation or expansion, that while Dr. Polydoulos has a right to freedom of expression and religion, these rights are subject to reasonable limits under the Charter. And that's the type of analysis I expect to see, on social media, on Twitter. It's like, oh, you have a right, but yeah, it can be limited. I see this all the time. Like, that's not an analysis. And there really needs to be an analysis for you to balance a statutory objective against a charter right. Just saying that a charter right exists and can be limited is not sufficient. So the case was never judicially reviewed, and I think it should have been because the reasoning is deficient. Physicians are entitled to practice their faith and make public statements about their religious beliefs without fearing that their regulator will discipline them. And in Polydoulos' case, the board barely mentioned her right to religious freedom other than to cite that it can be limited under Section 1. And that is not the required balancing of charter rights against the statutory rule of the regulator. It's just a bare acknowledgement that a balancing should take place. Finally, there's this really interesting juxtaposition of two cases that I consider in my paper, which had really different outcomes. And they involved medical workers and political speech. And when you read these two cases, you really get a sense that it's the political content of the speech that explains the different treatment of the two professionals. And one case involves speech by this polarizing anti-abortion activist named William Whatcott for his activism against Planned Parenthood while he was a practicing nurse. And the other involves a complaint about an anti-firearms activist and physician from Ontario. So first, let's consider Whatcott's case. And look, I really hate to have to say anything in defense of Whatcott because he is kind of a famous homophobe. He has said some really awful things. And his case, in an unrelated case, is actually the leading Supreme Court decision on hate speech. But this is a separate case, and it involved his nursing license, and he actually won this case. So many people are familiar with his other famous case, and they might not know that he was also a registered nurse and that he used to picket Planned Parenthood offices as part of a pro-life protest. And he would picket them with those pictures of aborted babies that we've probably all seen. And because he was a nurse, Planned Parenthood went after his nursing license. And keep in mind, if he had not been a nurse, if he'd been in like financial services or, a grocery store clerk or in any unregulated profession, they would not have been able to go after his livelihood. It was because he was a nurse. And the nursing college found Whatcott guilty of professional misconduct for his protests. They imposed a large fine, $15,000, and they suspended his license. And without even mentioning the charter, the committee found that the manner in which Whatcott conducts himself while picketing may constitute professional misconduct. And Whatcott took his case to the Court of Appeal, where the discipline was set aside. And the Court of Appeal found that there was no evidence that anyone thinks any less of nursing because of his protests. He didn't even publicly identify himself as a nurse. And that the connection between his protests and nursing as a profession was tangential. The only link is that abortions are a medical procedure, and that's not enough of a nexus to the profession to bring his protest within their jurisdiction. And the Court of Appeal held that the professional regulator has no authority to police a professional's expressive activity on topics that have no connection to the profession, whether it be expressing an opinion privately, engaging in public advocacy, or large-scale political organizing, including if language is used that's controversial, offensive, or even repugnant. And so as a result, the Court of Appeal set the discipline aside. So Whatcott's case is about political speech. And I want to contrast what happened in his case with another case called MRM and NAA. And like Whatcott's case, this case dealt with political expression that was only tangentially connected to the medical field. But unlike Whatcott, the case in MRM got no further than the Health Professions Appeal and Review Board. The case involves Dr. Najma Ahmed, who is a trauma surgeon and the founder of a public advocacy group that calls for gun bans and considers guns to be a public health issue. So Ahmed had expressed her opinions in the media and on social media, and as a result, nearly 70 complaints were filed with the College of Physicians and Surgeons alleging that Ahmed's advocacy for gun control constituted immoral and unprofessional behavior. And a Canadian gun lobby group had encouraged members of the public to write in these complaints. So the college investigated and determined to take no action. The college called the complaints frivolous and vexation and said that the college's procedures should not be abused to advance a political agenda or silence or intimidate physicians. The college added that using the process for political purposes is inappropriate and that the college has no role in regulating this political debate. And look, I agree. As a matter of political expression, without any link to the profession, this was the correct outcome. But what's really noteworthy is that in Whatcott's case, his political expression resulted in discipline that was appealed all the way to the Court of Appeal until it was finally overturned. Whatcott would have incurred significant costs associated with all of those appeals, and many other people in his situation would have just given up and submitted to the discipline. So despite the similarity in the cases, which both dealt with pure political expression, the initial outcome and the process in Whatcott's case were an immense burden on him compared with the immediate rejection of the complaints in Dr. Ahmed's case. And really, I can't help but conclude it was a subject matter of the political expression that influenced these different outcomes and processes. These cases, all of these cases that I've talked about, Peterson's, Strom's, Polydoulis's, those OMA doctors, and Whatcott and Ahmed's, they all highlight a number of different problems. There's a problem with regulators expanding claims of jurisdiction over what off-duty conduct they can regulate and the generous definition that they're giving themselves of what actually constitutes the public interest. There's a problem with the courts then giving deference to those expanded claims of jurisdiction, as well as giving deference to the decisions of the regulators who show very little, if any, concern for charter rights. There's a broader cultural problem with the devaluation of the right to freedom of expression. And that's really awful. Freedom of expression fosters human flourishing by permitting us to convey our beliefs, thoughts, and ideas and emotions without having to fear state-imposed restrictions or punishment. And on a societal level, freedom of expression enables democracy to function, and it encourages the search for truth in diverse fields of inquiry. This principle is really vital in truth-seeking professions like science, medicine, law, and other professions that thrive on constructive debate and disagreement. And the discovery of new ideas would be chilled if professional regulators were empowered to police their members' speech for ideological conformity and political correctness. But that's what we're seeing happen. Now, in my paper, I suggest a few practical steps that can be taken to address some of these problems. So first, I think that regulators should receive comprehensive training in constitutional protections, particularly freedom of expression, because, regulators might possess technical expertise in their respective fields, like they might know a lot about the practice of medicine, about what surgeries are right, or what surgical procedures need to be done in what cases. Or they might be really knowledgeable accountants about how audit procedures should work. But a lot of them lack knowledge about constitutional rights. And I think that training regulators and equipping them with an understanding of constitutional rights would equip them to appropriately balance the regulatory goals of regulating in the public interest with the fundamental right to freedom of expression, because those things need to be balanced, and right now the balance is way off. A second thing that could be done to improve protections on freedom of expression is that legislatures could codify the standard of review. When courts review regulators' decisions, they use that deferential standard of reasonableness, not correctness. And we saw in Peterson's case, when his case was reviewed for reasonableness, there was all of this deference given to the regulator. But in cases like Strom and Whatcott, where the standard of review was correctness, in those cases, the courts overturned the discipline for failing to take proper account of the constitutional rights of individuals in regulated professions. So legislating a correctness standard of review for cases that engage the right to freedom of expression could ensure more robust protections for the right. Third, legislatures could amend existing statutes to require regulators find a significant connection to the profession when addressing issues related to off-duty speech. Now, the case law already requires there to be a nexus or connection between the off-duty speech and the profession, but there have been really big inconsistencies in how this has been applied. And I think codifying that requirement could help prevent regulators from overreaching and infringing on freedom of expression without a substantial connection to professional conduct. Finally, I think that there needs to be public advocacy to foster a cultural shift that would elevate the perceived value of freedom of expression. And there's this current trend of cancel culture, like go after that person, make them unemployed. And this poses a really big threat to open debate and the exploration of diverse viewpoints, which is really important within regulated professions, which are truth-seeking professions. But it's a problem within the professions and beyond. So I think it's essential that Canadians advocate for societal change to recognize and uphold that expression is a vital part of truth-seeking and democratic discourse. And that cultural shift can then be internalized within the values of the individuals who make up these regulatory bodies. Do you have any ideas of how to improve freedom of expression, protections in regulated professions, or more broadly? Are you a member of a regulated profession and worried about the chill on your speech? It's been really incredible since my paper came out, the number of people in regulated professions who have written to me privately to thank me for the paper and to say how scared they are every day of losing their license because of a political view that they expressed on Twitter. Is it something that you worry about? And which of these cases that I described here stands out to you the most? Leave a comment below because I always really love hearing what you think. And if you want to learn more about this, please look at my paper, which I've linked to in the description below. Okay, that's all for this update. Thanks for watching, and let's keep fighting for freedom in Canada.